This hearing is in the matter CFI 22 of 2018 before the Deputy Registrar Nour Hineidi and is being held by way of teleconference. The applicant, Khaled & Co., is not party to the proceedings and is not in attendance today. The claimants are represented by El Tamimi & Co. The defendant is represented by Horizons & Co. Law firm and is also not in attendance today.
Thank you very much, Alia. So, Mr. Smith, thank you very much for conferencing in. The reason why I wanted to have a quick hearing on oral submissions is because, as you know, the Khaled & Co. being a non-party to the proceedings made an application to avail certain documents, being copies of pleadings and judgments issued in this case. So we've had obviously some pushback from both the claimant and the defendant in terms of the provision of any documents, but they provided, on the other hand, also good reason for why they request copies of these documents. So I wanted to hear from you first before I made a call on the application, and that's it.
Well, thank you very much, Deputy Registrar. Do you have a copy of Khaled & Co.'s letter in front of you?
I do, thank you.
I mean, the reasons for the request are set out at paragraphs 5 and 6 of their letter. It might be helpful if we turn to those.
Just bear with me, Mr. Smith. I've got a one-page letter in front of me. I'm not sure if the other one has been uploaded. Just bear with me, please, while I quickly locate that. Maybe I can ask the registry to assist. Alia, would you mind, if you've got a copy handy in front of you, there's a problem with the CMS, would you mind forwarding me a copy of the long letter which was sent by Khaled & Co.?
Sure, no problem.
Okay, I've actually found it. Mr. Smith, paragraph 5 and 6, thank you.
Paragraph 5.1, they set out that they want to further understand the approach of the DIFC courts to issues pertaining to the validity of constitutional documents and ancillary agreements of entities incorporated outside the DIFC and the application of contractual interpretation rules with respect to company documents together with nominee or side agreements. Well, the truth is that the hearing was an injunction hearing. That is to say, it was the exercise of the court's discretion. There's very little probative value for 1 and 2 under paragraph 5 from any injunctive proceedings. I mean, the validity of the treatment of constitutional documents and ancillary agreements, that requires a reasoned judgment, which doesn't exist in this matter. The application of contractual interpretation rules, well, that's presupposing that there was an application of interpretation rules, which there wasn't. Again, it requires a reasoned judgment. The only way that they could get any information from the Sharma proceedings which go to either one of those points is not actually in the orders itself, but it's in the transcript they ask for at paragraph 10. Now, my understanding is that there is a transcript of the ex parte injunction order, but I think that that was probably private, those proceedings. The hearings were indeed, I think, private until the case had reached a certain point.
Because I'm taking a look at the CMS, sorry to interject, Mr. Smith, and the case has been marked as private. Sorry, it has not been marked as private. So I'm wondering where, and I did see the correspondence that was flowing between Tamimi and the registry at one point. And I think that there was mention in your submission that the case was initially private. But could you just walk me through why you think that's the case? I suspect that when the initial injunction was applied for, the case would have remained private on the basis that it's an injunction, so for obvious reasons. But when the injunction was then served on the defendant, the case would have then been treated normally, and the default then is that it becomes public. But I'll let you just walk me through that.
Well, but that's fine. But that means, doesn't that mean that everything after service is published?
Correct. Yes.
Yeah. So
I see your point now. Yeah.
Is the hearing before service? Is the ex parte injunction order? That's the transcript that I think is the most relevant for what Clyde & Co want, but that's private because it was before service of the documents.
Correct. Okay. Actually, this is something that I do need to check with the registry, because some cases, even after service, if any party, including a interested third party or a third party who's been put on notice of the injunction proceedings, of course, including and as well as the defendant, if they request a copy of the transcript, they are perfectly within their rights to do so. And after service, you can then backtrack and make everything else public in the case. But was there anything, so if that is the case, and we can make the transcript public on the basis that it has been made public in other cases, is there any reservation that you might have about the privacy of anything discussed at the initial injunction application hearing?
Well, it is. It's about the relationship between the defendant and the claimants, in that this case settled. The injunction application was the airing of the dirty laundry that was the basis of the injunction. There was a lot more said at that hearing than there was contained within, for example, the law update article that Clyde & Co have seen. So I don't have a copy of the transcript open right in front of me, but nonetheless, it was a much more substantial hearing than, or much more substantial airing of grievances than what appeared in the law update article. But again, it was all the application of the court's discretion, and so there's nothing probative or that engages stare decisis for the validity of constitutional documents and ancillary agreements of entities incorporated outside the DIC, or the application of contractual interpretation rules. The thrust of the law update is that the court has recognised side agreements or nominee agreements as the basis for jurisdiction, of a finding of jurisdiction. And that's it. And that's what the law update article says. I just don't see how the transcript would assist them in any way, if they're thinking of making an injunction now or resisting an injunction or bringing proceedings, compared to a judgment. And their obvious source, if there isn't, they can't find one from the DIFC's publication of judgments. The obvious thing for them to do would be to look to other common law jurisdictions to look for analogous occasions.
Good, yeah.
Do you see that? Mm-hmm. So that's, I could come to, you've seen our objections in our emails. Looking at paragraph 6, though, of their letter as well. The request for statements of the case is made in order to better understand the judgments in relation to the proceedings. But the judgments, firstly, there are no judgments, they're just orders. The first order is the ex parte interim order, which made the Sheikh do various things and refrain from various things. And then that was upheld at the return date. And then we discontinued proceedings because the parties settled. So there's no better understanding. There's no jurisprudence that is revealed by any of those orders. And so there would be nothing for them to better understand.
Yeah, I see your point.
I understand that Clyde & Co haven't really pressed this very hard. They've written the letter, they've set out why. But I mean, basically, this is on the phishing side of an inquiry rather than a specific point. We've discussed outside this hearing the issues on, for example, articles under DIFC law. Article 150 of the DIFC contract law, and if a law firm is or a party or council are looking for cases that have interpreted that, they search online, they look at the volumes, the Montague Smith and Reed book, and these other sources of information. But broadly speaking, it's until it's captured properly by Westlaw or PLC or wherever it is, it's difficult to carry out those searches. And so, in the absence of a lot of authority on Article 150 of the contract law, I could understand why a law firm would write a letter like this and try and invoke an exception to the general rule under Part 6 of the RDC and obtain copies of a reasoned judgment that gave colour. But this isn't one of those cases.
Yeah, I agree with you. I see your point. And I do agree that it's more on the fishing expedition side than a more specific request for information. And obviously, had Clyde & Co been on the call, they would have made their submissions in response of that, but they chose not to be on the call. So, well, I'm convinced, Mr. Smith. I will make an order that the application be denied, and I don't see any point in wasting your time on this any further, or the court's time. So I will reject the application. Ali, if you wouldn't mind preparing an order to that effect.
I'm very obliged. Was that to me to prepare the order?
No. I'll ask the registry. Alia, are you on the phone, please?
Oh, right.
Yes.
I think you might be on mute.
Yes, no problem.
Thank you. Thank you so much, Mr. Smith.
I'm much obliged, Deputy Registrar. Thank you.
Thank you. Have a nice day. Bye-bye.
Bye-bye.